Hello, everyone. Welcome to the 2022 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Interim Dean of the Graduate School and Associate Dean for Environmental Programs, and I'm a professor here at Vermont Law Graduate School. We're very pleased to welcome you to our presentation today. Each of these talks is worth 1 Vermont CLE credit. So if you'd like to claim that credit, please keep track of which talks you attend for your records. And please hold your questions until the end of the talk. We'll have time for Q&A after today's presentation. For those of you who are watching on the VLGS YouTube or Facebook, you can enter your questions in the chat or the comment space at any time, and we'll get through those as many as we can during the Q&A. So you can enter them as you think of them, and I'll collect them for the end. Today, we are extremely pleased to welcome Sean Donahue as our speaker. Sean is a partner at Donahue, Goldberg, and Littleton, where his practice is focused on appellate litigation with a focus on complex environmental and administrative law cases in federal and state appellate courts. He's a graduate of the University of Chicago Law School and served as law clerk to then-D.C. Circuit Judge Ruth Bader Ginsburg and to Justice John Paul Stevens. After entering practice at Jenner and Block, he spent 4 years at the Appellate Section of the Department of Justice's Environmental and Natural Resources Division. And since he established his own practice in 2002, Sean has represented environmental and public health organizations as parties in major environmental and clean energy cases in the Supreme Court, the US Supreme Court, and the Courts of Appeals. He has taught courses in environmental law, climate change law, civil procedure, constitutional law, and other subjects at various law schools. And currently, he's teaching a new summer course at our school called Environmental Appeals, which we're very excited about. Today, his extremely timely talk is titled "The Clean Power Plan Litigation and the Path Ahead for Power Plant Greenhouse Gas Regulation." Please join me in welcoming Sean Donahue.
Thank you so much, Jenny. It's great to be here, and really excited to get a chance to talk about this very chastening and painful episode of my life, the Supreme Court's 6-3 decision 2 weeks ago today, overturning the DC Circuit on its decision, which in turn had overturned the Trump administration's undoing of the Clean Power Plan, which is kind of a short biography of at least the last 7 years of my life, since I've been working on the Clean Power Plan and various phases of the litigation over it since 2015, when the Obama administration finalized that rule. I'm going to just say, give a brief description of sort of how we got where we are now, and a brief description of the decision on January 30th in West Virginia versus EPA, the sort of central points of the majority decision in particular, and then I'm going to make a few observations about the case and sort of where it may leave us. And I really, I know many of you, perhaps most of you, have looked at the decision, certainly read about it, and are having thoughts and questions about it, and we're still very much in the process of figuring out what this means. It's obviously a big event, and it's going to kind of play out over time. So I really welcome questions and comments at the end. I'm going to make sure to leave time to do that. So this case is about rules that the EPA adopted under Section 111D of the Clean Air Act, which requires EPA to regulate emissions of dangerous air pollutants from categories of stationary sources. And these rules involve emissions of carbon dioxide from power plants, which are the largest stationary sources of carbon dioxide. In 2015, the Obama administration finalized the Clean Power Plan, which was an ambitious rule to regulate CO2 from power plants, and rested on the Obama EPA's finding that the best system of emission reduction, which is a key language under the statute, everyone agrees, for power plants, involved a kind of combination of measures that included shifting power generation from higher generating to lower generating facilities, including from coal and gas plants to renewables. And the standard that EPA set was kind of based on an analysis of how much of that generation shifting could feasibly and at reasonable cost be done over time. And the Clean Power Plan set a target, which was sort of an estimate of how much emission reductions would occur applying the rule of 32% of emission reductions from the sector over 2005 levels by the year 2030. The Clean Power Plan never went into effect because although a sort of diverse panel of the DC Circuit, after laborious and lengthy briefing on a stay motion, there unanimously denied a stay. The Supreme Court, by a 5-4 vote in February 2016, stayed the Clean Power Plan, and it sort of never went into effect. After President Trump came into office, EPA began a process of reconsidering it, which led ultimately to a repeal of the Clean Power Plan 2019, combined with the promulgation of a rule called the Affordable Clean Energy, or ACE rule, which involved significant, dramatically less ambition. EPA forecast only a 1% reduction. There were critiques that the rule would actually lead to an increase of emissions because it focused on improving the efficiency of coal plants. And that rule completely didn't regulate gas-fired power plants at all. That rule was challenged by a broad array of states and power companies and NGOs. And that litigation culminated in January 2021 on the literal eve of President Biden's inauguration in a decision by the DC Circuit holding that the Trump EPA had repealed the Clean Power Plan based on a mistaken understanding of the Clean Air Act that was too narrow. The Trump administration had said that the Clean Air Act clearly prohibits EPA from basing a rule on generation shifting. The DC Circuit said that's not right. The rule does not impose that limitation, and on that basis alone, vacated the ACE rule. Right after the decision, EPA came in and asked the court for an order staying the Clean Power Plan and making clear that no obligations under the Section 111 would be placed on anyone, including power plants and states, until EPA completed a new rulemaking that it intended to complete. At that point, there were a bunch of cert petitions filed seeking to review of the DC Circuit decision, but there was a sense that the court would probably let this one go because there's no rule in place, no one is suffering any harm, and the administration had promised to do a new rulemaking. The court last fall, after relisting the case a bunch of times, granted cert. At that point, there was a sense that there was probably trouble for the supporters of the DC Circuit decision and for a broader understanding of EPA's authority, because it was such an obvious case for the court to kind of let it go, that a grant meant that some members of the court were eager to sort of do something big on the law. And I think it's fair to say that's ultimately what they did. The decision from 2 weeks ago today first rejected very energetic arguments from EPA and from its supporters, like my clients, arguing that there was no justiciable controversy before the court. No one was injured. There was no rule in place. There was no way the Clean Power Plan was going to be reinstituted or enforced against anyone. The court rejected that and said, really, it should be a mootness analysis, and this was a voluntary secession by the government of its own rule. And the question was whether it's possible that EPA could adopt another rule based on generation shifting, and the court thought that was possible, and therefore the case could be heard on the merits. On the merits, the court began with an elaboration, and it's first ever in a majority opinion use of the phrase major questions doctrine, in which it explained that, or it recited certain extraordinary cases in which the court said an agency has done something of such economic and political significance that the court should review its claim of authority with a measure of skepticism. And the court went through a number of cases, including the Brown and Williamson case involving regulation of tobacco by the FDA, in which the courts have said, we find this claim of agency authority sort of implausibly broad or ambitious, and we're going to ask for clear legislative authorization. We don't find it. So the court kind of presented the series of cases as a sort of coherent doctrine in which agencies have, in the court's words, asserted highly consequential power beyond what Congress can reasonably be understood to have granted. This was just such a case, the court said. The Clean Power Plan was an attempt to substantially restructure the American energy market. It was an attempt to do things that Congress had specifically declined to do, like establish a cap and trade program for carbon. The mode of regulation, including the reliance on generation shifting, on shifting activity from regulated sources to non-regulated renewables generators, was unprecedented. The court said there was nothing like it, and that questions like reducing coal's share of the national energy market are sort of too big for EPA to decide without a clear warrant from Congress. The court, after sort of starting with the major questions doctrine and declaring that this was clearly sort of the kind of case in which that exceptional kind of analysis applied, turned to a textual analysis, and the court said, yes, system is a broad term, but it's sort of unhelpfully broad, and it's not the kind of clear authorization that's required to do something as consequential as capping carbon dioxide at a level that would force a national transition away from the use of coal for power generation. A decision of such magnitude and consequence, the court said, belongs to Congress itself or an agency acting pursuant to a clear delegation from that representative body. So that's basically the decision. The major questions doctrine plays a central driving role. There's some statutory analysis. The court does not sort of parse the statutory terms too much. The court does not say exactly what EPA can do going forward, but what it clearly can't do, in the court's view, is adopt generation shifting that is sort of designed to reduce the amount of coal generation in favor of renewables. There was a concurring opinion by Justice Neil Gorsuch with a join from Justice Alito that sort of laid out the major questions doctrine in a somewhat more structured way, and I would say a more aggressive version of the doctrine. I'll say a little more about Gorsuch's version. And then there was a dissenting opinion from Justice Kagan that accused the majority of limiting EPA's authority in a way that flies in the face of the statute. She really pushed the theme that the court should never have taken the case because of its posture. And she accused the court of sort of abandoning its professed interest in textualism in favor of a sort of amorphous doctrine that allows the court to sort of override statutory text in an important situation in which, in Justice Kagan's view, Congress really did authorize and direct EPA to address this sort of singularly difficult problem and devise a means that is workable and sensible. So I'll just say a few things, a few sort of general reactions to the decision or thoughts about it. and then I will invite comments. So first of all, I mean, I think the court's decision to take the case is one of the most troubling things about it. I think this is the decisions to grant the tiny fraction, one of a tiny fraction of cases that it has before it is an important exercise and a revelatory exercise of the court's discretion. And this was really a case where there was a strong case for letting it go. There was just no one in this the world of debate and litigation of the Clean Power Plan seriously thought the Clean Power Plan would ever, whatever courts said, go into effect or be applied against anyone. For one thing, the emissions targets that the Clean Power Plan set for the year 2030 had already been surpassed by the market, even with the Clean Power Plan not into effect, because of shifts to low-cost renewables and shifts from relatively high-emitting coal to gas generation. The rules, the timetable for implementation of the Clean Power Plan had already passed, so there would have actually needed to be some new rulemaking to establish a new timetable. That was not going to happen with a rule that had no environmental benefit anymore, and an agency that said it wanted to do a wholly new rule. So it was really putting aside the technical Article 3 analysis, which I think the court did not take nearly as seriously as it should have. It was really a case for letting the case go, even if justices may have strong feelings about the Clean Power Plan or serious concerns about its design. This was really a case where, in my view, the court, understanding its role in the system, should have let a new administration take a crack at it. And I think that's a theme in Justice Kagan's dissent. She talks about she uses the phrase, the boogeyman of environmental regulation. I think that was really evident here, that for some justices, the idea that EPA might in the future do something really ambitious on climate is very deeply concerning, and it led them to sort of run past what I think in retrospect or in comparison to historical practice would have been a really strong case for denying cert or dismissing the petition. So that's number one. I think that the decision to take the case is sort of suggestive, along with a lot of the court's activity in the shadow docket. I know it's going to be the subject of another of these talks by Bob Percival. There's this sense of sort of looming superintendence of particularly sort of administrative action, particularly perhaps in the environmental area when there's a Democratic president. That's number one. Number two, I think the most important feature of this decision is surely the reliance on the major questions doctrine and the sort of presentation of it in both the majority opinion and the Gorsuch concurrence. Because, as has been pointed out, it's potentially a very broad application to a wide variety of agency actions. No doubt there will be a lot of activity in lower courts, and already we're seeing claims based on major questions seeking to sort of undo agency actions in a sweeping variety of areas. As presented in the majority opinion, which relies largely on sort of discussing and citing the analysis in a series of cases that are pretty eclectic, including some cases like American Trucking versus Whitman and MCI versus AT&T, where the court struck down a deregulatory action or arguments against regulatory approved regulation in the case of Whitman. To a large extent, it's sort of a series of holdings that then are presented as representing a doctrine. By my count, there are perhaps 7 distinguishable sort of factors that the court elicits that together made this an extraordinary case for application of major questions. The breadth of the claimed authority, sort of bigness, economic and political significance. This is all one factor, by the way, regulating a significant portion of the economy. or that would settle or amend a major social or economic question. I'll call that all sort of bigness of impact. The fact that the agency has infrequently used the cited regulatory authority, rarely used or unprecedented type of agency action, an unusual type of agency action, maybe that's distinguishable, statutory language that is sort of subtle or elliptical, not pointed enough to authorize the action, action that is outside the agency's traditional area of expertise. Here, the court viewed EPA as sort of regulating the power grid, the power industry as a whole, rather than regulating particular factories and smokestacks where the agency might have, in the court's view, more expertise. Prior congressional action, effort to do the same sort of thing. So if the agency is attempting to do what has been attempted in legislation unsuccessfully, like a cap and trade program, that is a factor suggesting it's a major question, and something that's been the subject of earnest and profound debate around the country. I think that's from the Gonzalez case, another factor. Now, I don't think that the court meant that if any of these factors is arguably present, it's a major question. I am sure that litigants right now are typing out briefs that make arguments that at least one of those factors is present, and that will go on for a long time. This is not a sort of tightly confined, constrained doctrine, and it will be used, and there will be a lot of litigation about it, and it is not clear when it applies and when it doesn't. The court does say it's reserved for extraordinary cases, and defenders of agency action will certainly point that out, and we will see just how extraordinary it is. The Gorsuch concurrence presents the doctrine in a much more structured way. He has sort of three factors that tell you whether it's a major question, and then a bunch of factors that help you resolve whether there is clear authorization to do that thing that presents a major question. And he kind of organizes the same factors in a different way, but he leads off with is the issue one of great political significance, which to me sounds extremely open-ended and subject to potentially to a kind of heckler's veto, where if, for example, a bunch of state attorneys general want to make something into a huge controversy, they do that, and then they claim that it's a major question, that the agency is subject to this kind of extraordinarily demanding standard for its regulations. So the Gorsuch approach obviously didn't get a court query whether some of that sort of analysis will make its way into Supreme Court majority opinions going forward. Okay, I will say, so you know, how the major questions doctrine plays out over time is, you know, going to be key, and obviously it's going to be raised all the time, and defenders of regulation will want to sort of dig in and say, no, this action is of a more traditional type, the agency's done this before, or it has a more limited impact. One thing that I think is a sort of mitigating factor is that the court describes the claim power plan in a way that we would probably, its defenders would probably say was not completely fair, but it describes it as kind of, you know, an extremely aggressive and really unusual, exceptional thing. And that may mean that in other cases where defenders can say, this is clearly not that, this is something more modest, maybe that is a limit on how the major questions doctrine will be applied going forward. I'll note, you know, it's not exactly clear what the decision, how it will apply in the context of power plant regulation. There's a lot of sort of ambiguous language in there about various topics like trading and fuel switching. But one thing that is clear is that a best system of emission reduction that is based on generation shifting is probably out. And I just want to note the sort of irony of that, because that was the sort of widely regarded as the cheapest and sort of in practice most commonly employed technique. It had broad industry support. A coalition of power companies actually argued this case at EPA's side in the Supreme Court. No power company, no regulated company sought Supreme Court review in this case. Yeah, so just kind of remarkable that the court ends up sort of overturning that and leaving EPA with tools that are probably less, favorably viewed by the actual regulated parties. You might say that it's sort of a similar irony with the attack on Chevron, which is no longer apparently good law, though it hasn't been actually overturned in the Supreme Court. In the lower courts, it continues to have some life. But that case involved a Supreme Court's upholding an agency rule that seeks to accommodate progress in reducing air pollution with economic growth. That was a Reagan administration rule that was involved in Chevron that was designed to increase flexibility and lower costs. So in both of these areas, the court is moving in ways that aren't necessarily congruent with the regulated industry's interests or positions, but some sort of broader project involving views of agency's role in American government is going on, and it's something pretty big. I'll note a bunch of sort of limitations. The case didn't go as far as some worry that it wouldn't, and it sort of clearly, for example, it doesn't address EPA's authority to regulate other source categories or under other statutes. And I think the sort of major, the initiatives that EPA has underway to deal with greenhouse gases, like regulating methane emissions from oil and gas facilities. That is a proposed rule that is much more sort of traditional looking. It regulates pollution from the sources, and it has some additional backing in terms of legislation in 2021 that clearly sort of affirmed EPA's authority there. I think also the motor vehicle regulations under Section 202, that is hardly can't be called, as the court called Section 111D, an ancillary provision or a backwater. That is the provision that was involved in Massachusetts versus EPA. It's been used many, many times, obviously, over time to regulate a variety of pollutants from motor vehicles, including greenhouse gases. And involves reducing pollution from the sources themselves. So I think in that way, there's some solace in the decision. The court didn't attack EPA's authority to regulate greenhouse gases under the act generally. And even with respect to power plants, there's some sort of limiting factors or tiny silver linings. The court sort of describes the regulatory regime in a way that recognizes that EPA has authority to make set binding limits that then state plans and sources have to meet. That was kind of a contested question. Parties have argued that EPA's role is more advisory, and that's clearly not the basis of this decision. The court leaves room for EPA to regulate as long as the regulation is sort of more conventional looking, oriented toward reducing emissions from the sources themselves rather than shifting generation. Even though any regulation that affects the cost of production, particularly in the power industry, is going to affect the degree to which different plants operate. So generation shifting will be a result, but it can't be, under the decision, I think, the target of the agency's action or the basis of the limitation. But there's room for the administration to operate even on power plants. So the Biden administration has committed to rulemaking to establish standards for existing sources, the ones that were at issue in the West Virginia case. And it's also endeavoring to regulate or come up with new regulations for new sources. And I'd say when it does so, it's going to confront a power sector that is dramatically different from what EPA confronted in 2014, 2015, when it was constructing the Clean Power Plan. As I mentioned, overall emissions have dropped very significantly, faster than the Clean Power Plan was expected to cause. And so there's been a faster shift away from coal generation. Renewables deployment has been faster than was contemplated, almost a decade ago when the Clean Power Plan was being devised. And so the Biden administration is going to surely want to take all that into account. It's also, that's sort of the relatively positive thing, is that emissions have been dropping largely because of coal retirements and deployment of renewables. But it's also going to have to confront the fact that we're building a lot of new gas plants, which also emit tremendous amounts of greenhouse gases. And if those emissions aren't controlled and we lock in emissions for decades from them, we're just never going to meet our climate goals. It's just unacceptable. So they're going to have to figure out a way to ensure that the building of new gas doesn't sort of undo all the benefit of reductions in emissions from coal. So I don't know. There's obviously a variety of measures that were considered even in the prior rulemakings that can be implemented at power plants that would be consistent with the construct that the Supreme Court appears to regard as consistent with Section 111's historic and proper function. Those include things like carbon capture, fuel switching, efficiency measures, and others. I'm sure EPA will be looking closely at those. And one thing I am very sure about this administration is that it will not do in coming up with new rules for power plants. What the Trump administration did with the ACE rule that made it quite an outrage, which is completely ignore the interest in reducing dangerous pollution. That was just sort of absent from the preamble. It was kind of extraordinary. The entire purpose of the exercise is to address pollutants that endanger public health and welfare. And I know this administration will take that seriously, which is obviously essential given where we are with mounting climate hazards that are pressing in our attention every single day. So I think at that point, I would really love to have questions or comments. There's obviously a tremendous amount more one could say or emote about this decision, but I'm really eager to hear questions. And so I think I will invite them now.
Great, thank you so much, Sean. Okay, so first, sort of a logistical question. You spoke about, when you were talking about the major questions doctrine, you spoke about the 7 factors, and one of the viewers was interested in knowing whether there was something they could read online that would tell them more about that.
Yeah, so I should say that my listing of factors is just derived from my own reading of the majority opinion, which talks about a series of cases like Brown and Williamson and the utility air regulatory group case, et cetera, and kind of pulls out from them these factors that led courts to interpret the agency's authority in a more skeptical way. So I would say I would read the majority opinion. That's like the best source on those. You could break them down like even as I said it, my classification of the second factor I said was sort of infrequent use of the statutory authority. And then the second one I said that the administrative authority was unusual. I saw that as different. Maybe one could say it's the same. Unusual to me might be referring to kind of the rule looks strange, even if it's been done before, but maybe you could compress them into 5 factors. Maybe you could squeeze them, elongate them into 8. They're generally derived from the court's kind of take on specific precedents, but that's kind of how they, the court kind of. I will note that the D.C. Circuit majority sort of discussed the major questions doctrine and ultimately concluded, this isn't that kind of case, because here EPA has clear, explicit authority to regulate these sources of these pollutants, and the major questions doctrine is about when an agency kind of goes off onto something that isn't in its wheelhouse. One innovation of this decision is to say, even when the agency is, and the court doesn't, it kind of acknowledges the American Electric Power case, that where the court had relied on the fact that EPA can regulate CO2 from power plants. It acknowledges that, but it says the major questions doctrine also applies to sort of how the agency regulates, which is I think kind of an innovation. So anyway, I think there's a tremendous amount of commentary and blogs and podcasts coming out, but I think I would start with the majority opinion.
A question for me, just for the benefit of the viewers, could you talk about your role in the litigation?
Sure. So I have represented Environmental Defense Fund in the original Clean Power Plan litigation and the Affordable Clean Energy one that became this case. And I've worked and helped to coordinate a group of NGOs, a large group, Sierra Club and NRDC and American Lung Association, many, many others, whose lawyers were actively involved in a huge part of this. And then I was counsel of record for that coalition in the Supreme Court. So we filed, our own brief. We argued in the famous 9+ hour oral argument in the D.C. Circuit, and then neither I nor anyone from our coalition presented argument in the Supreme Court. Because you can only have sort of 2 on a side, and we thought maybe we wouldn't be the most effective messengers. The case was argued, as I mentioned, by the Solicitor General and then by Beth Brinkman from Covington and Burley, who argued for power companies very effectively. So that was my role, and I'm continuing to work with the same coalition as we figure out what's next with the litigation, which of course isn't over. Yeah, so I mean, that's one major silver lining, is that there's this huge coalition, not only of all those NGOs, but also a very large coalition of states and cities and of power companies, renewables, trade associations, and others. And I think that over many years, I think that coalition have built relationships and drew on each other's expertise. I think that's going to be helpful going forward, both in administrative advocacy and litigation that may follow.
Thank you. So the Clean Power Plan, as I understood it in the decision, relied on 3 different ways of reducing emissions from the power sector: cleaning up existing coal, cap and trade, and shifting your own plant's generation to a cleaner source. And so one of those 3 was the sort of filter on the smokestack kind of on-site, not beyond the fence line kind of regulation. And so it wasn't clear to me from the decision that they really parsed those 3 different strategies. It would seem that the first would be within the realm of what they say EPA has historically done and what they mean with BSER. So, I mean, they did say, Roberts did say that it was going to be so expensive for the coal plants to do the kind of compliance that they'd have to do under that first option, that it was de facto generation shifting. But so where do you see, are there any cracks there? Do you think the decision applies equally to each of those 3 components in the Clean Power Plan?
Yeah, so as EPA put it, there were these 3 building blocks, which you noted. That the first was efficiency measures, which increase the amount of electricity you get per unit of fuel, and increase the amount of electricity you get per unit of pollution. And then the second building block was shifting from existing coal plants to natural gas plants, which emit less and probably on a life cycle basis are cleaner than coal, although there's a tremendous problem, as everybody knows, of emissions in this sort of getting the gas out of the ground and into the plant. A lot of very, very potent greenhouse gas emissions there, which hopefully EPA is going to really really help abate with its rules for the oil and gas sector. And then the third was shifting generation from fossil generation, both coal and gas, to new renewables. And I think the decision is not, if it may be said to be an advisory opinion, which the dissent kind of suggested, we kind of suggested it would be if the court reached the merits. It's not very specific on its advice. It says that I think generation, a rule where EPA says, as the court saw it, we're going to reduce the amount of use of coal plants by a certain amount, sort of top-down approach. We're going to kind of force that and set a standard that forces that. I think that's clearly out. On one view of this, because the court used this kind of gestalt approach to the major questions doctrine, maybe if EPA did a rule that was just kind of more, had fewer of the elements of the Clean Power Plan, but didn't totally eliminate them, maybe that wouldn't trigger it because it's for extraordinary cases and maybe only some of the factors will apply. That's not clear, but I think generation shifting is the clear sort of main target, and the sort of appearance that EPA is regulating the electricity market as a whole rather than particular facilities and their pollution. So I think I agree that sort of building block one and those sort of reducing pollution at the plant, and of course there's a lot of other things that you can do besides increasing efficiency and getting new turbines and new equipment at a plant to make it more efficient. There are things like fuel switching, carbon capture and sequestration that have this kind of reducing pollution from the individual sources character that would seem to avoid the objection. I think EPA is going to be looking at all this stuff. I think the opinion is ambiguous about sort of what is permitted, and that it's troubling to me that there's a sense of, we'll tell you if the new thing. I think the court doesn't say that sort of cost alone. There have been a lot of Clean Air Act rules over time that impose some costs. Of course, they impose very large benefits. And one of the concerns about this, there's no discussion of the benefit side of the ledger here. There's citation of some really exorbitant cost estimates that were kind of risible when made. But over time, as I mentioned, the unregulated market outpaced the Clean Power Plan. So the idea that it was like unreasonably rigid and draconian is, we have had a test of that and it was proved to be false. And that's the opinion, I feel, suffers from a bit of a lack of candor, not dealing with that more directly. So I think, anything that is sort of at the source, is much more likely to be, not regarded as sort of, extraordinary and warranting this special treatment. But we will see.
When you have the benefit of a life appointment to the highest court in the land, the necessity that most of us feel towards showing balance doesn't really apply to you. There's very, very little effort towards showing balance.
Yeah, I mean, I think obviously that it's like a virtue of judging generally, and I think I think that the justices probably do see it as a value, but I think there's just a sense of about some of these hot button issues that of kind of eagerness, and I would have said over eagerness in the context here to make these big changes. Anyway, I'll stop there.
Thank you. Okay, question from a viewer. Have there been any historic cases where the EPA has been successful in, quote, regulating industry?
Yeah, I mean, so I think, you know, obviously the government would not have, and I think we wouldn't have really agreed with the characterization that this was an effort to regulate at the sort of broad industry level. The Clean Power Plan best system of emission reduction arose from this like huge consultative process, including looking at state programs and looking at what power companies were doing, and sort of building a rule that reflected that, while also including some ambition to reduce pollution and risk to public health. And so the charge that it was a sort of, you know, Politburo style effort to regulate from the top, I don't think is really fair. But you know, there are obviously a lot of rules, and obviously this regulated just you know, electric generating units. It wasn't all of industry. It wasn't like the failed you know, national legislation that would have established cap and trade nation for across the board. There have been rules that have been upheld that, you know, had very broad impact, even like in the EME Homer case involving interstate air pollution, where the majority, including the Chief Justice, voted to uphold that rule as an example of a rule that really did, you know, have you know, real ambition and apply very broadly. It was consequential. I think the court saw that as a more traditional, even though it relied on you know, emissions trading and flexible mechanisms, not dissimilar to the Clean Power Plan. The court, it was obviously a different court too, but it regarded it as more conventional than this and more acceptable.
Okay, thank you. I wondered if you could talk a little bit about the legislative history aspect in this case. It was something that was not really addressed in the opinion. I imagine it may have come up more in briefing or at oral argument, but it seems like sort of a strange approach to legislative history in this case, where, first of all, in terms of statutory interpretation, the court says, well, the EPA has never used the BSER provision or this section of the Clean Air Act this way before, so therefore that must not be what it's meant to be used for, which is a very strange thing to say when really, you know, what the court would typically look at for statutory interpretation is, well, is this what it says? Is this a reasonable interpretation of what the language says? And so here they're saying Congress obviously didn't mean for EPA to use the Clean Air Act in this way because it's such a big deal. They would have said so if they did. But did anybody point to the fact that like an absence of discussion by Congress on this specific issue is not the same as Congress saying, we don't want you to do that with this?
Right. I mean, there was a lot of briefing, including some very strong amicus briefs pointing out that, you know, the Clean Air Act is not chopped liver. It was intended to do big things, and that provisions like Section 111 were written broadly, precisely so that EPA could, you know, deal with newly arising threats and problems and technical challenges. The way the court described the very same provision in the American Electric Power decision, you know, a decade earlier, you know, is quite different. It really does describe it as a big thing, and EPA's authority is very broad and with discretion to figure out how to solve this or address this problem. So yeah, I see it as grudging. I particularly regard the characterization of 111D as ancillary and as a backwater as pretty unfair and troubling, because it does feel like this is actually an important piece of a statute. This is really not a footnote. Admittedly used less than some other pieces, but not, you know, this sort of you know, idea that you have to use it in all possible ways as quickly as you can. I assume the court wouldn't like rules in which the agency says, well, we're trying to use this rule as broadly as we can, because if we don't, we'll lose it. And that's our reasoned explanation for why we're doing it, because the court will say we've lost it, we might need it later. I don't think the court would allow that, but it's sort of an implication of the logic here that an agency should do that.
Yeah. Okay, one more question. So the case really restricts the ability of the executive branch and executive agencies to do much of anything where Congress has not explicitly said, we give you, the agency, the power to regulate in this area. It really kind of feels like it charts new territory there. And I'm seeing another question, so we'll make this one the second to last question. That's going to come back to bite Republicans later, because it's currently the fact that, a liberal, a Democratic executive branch wants to do something that Congress won't let them do. But Trump tried to do things with his agencies in the executive branch that could have run into this same problem. So isn't it, to the extent that one sees this conservative opinion as ideological, isn't that going to just come back to bite Republicans later?
Yeah, so I think that the way you described the scope of this opinion at the beginning was a little more scary than even it is, in that I don't think the court's saying you have to have explicit authority sort of every time. I think, in cases where the regulation looks either more conventional or, I think that there will be claims that it is that demanding. I think that's right, although I'm troubled by the fact that it seems to be a somewhat amorphous, we know it when we see it aspect to it. So query whether it's kind of a general tightening of oversight over the executive branch. If it were a rule involving immigration or counterterrorism and the like, would the court apply similar sort of stringent approach? I think the Chief Justice presents it, I think, as a common sense rule that has been applied in a bunch of contexts, including ones where, environmentalists were cheering, like Whitman versus American Trucking, and it's not that big a deal. This is a doctrine, and I think the court's application of similar principles, including in some of the COVID cases, most notably the OSHA vaccine case, gives cause for concern that it's going to be used in a way that's really aggressive and maybe not always even-handedly, and that will remain to be seen. I expect over time that the law will evolve such that it is used in a fairly sparing way, but I think it'll be a very bumpy road to get there. I think there'll be a lot of efforts in lower courts to use it very aggressively.
Yeah. Okay, truly the last question here. Do you think the EPA will now put more of a focus on Section 112 of the Clean Air Act and focus on the public health by setting stricter standards for mercury, et cetera? And if so, and if the indirect result of these standards was to require most coal-fired power plants to close, would this court likely see that as the EPA just trying to get around their ruling?
Right. Well, I've done a lot of work on mercury, including another unfortunate Supreme Court experience in the Michigan case. Mercury is a serious public health threat that deserves attention, and power plants remain the biggest sources. We need to control mercury and other toxics from power plants. That is a sort of independent and sufficient basis for regulating under Section 112. It is true that any kind of regulation, coal plants are really high polluting, and they've sort of gotten away over a long time with imposing massive burdens on public health, and that they are now having to sort of abate some of that pollution, and that some of them can't economically operate without this sort of free ride in terms of disposing of their pollution in the atmosphere. Like that seems fair. I don't think the Biden administration will, use that as a way to get around its, or deal with limitations on its 111 authority. I think Section 112 and the interest in reducing toxics is ample reason. I think EPA has a whole bunch of things that it can still do under Section 111D. Notwithstanding this decision, I think there's a tremendous team over there, and that they will, roll with this punch and move forward in a way that is, consistent with their responsibility to the public.
Okay, we're out of time. I think I feel slightly better, which is not what I was expecting coming out of this talk. So thank you for that sliver of silver lining, maybe. Thank you, Sean, for your presentation, and thank you to all our viewers for joining us today. Our next talk will be on Tuesday of next week, and we hope you'll join us then. Thanks.
Thank you so much.